And so now, to start us off, it is my privilege to introduce the head of ADB's Office of Anti-Corruption and Integrity, Mr. John Versant-Fort. Welcome, John.
Distinguished guests, dear colleagues and panelists, I am pleased to welcome today representatives from many of ADB's executing and implementing agencies. We are grateful for our partnership and work alongside you day in, day out to implement our joint vision of a prosperous, inclusive, resilient, and sustainable Asia-Pacific region. Given your proximity to ADB financed development projects, most of you will be familiar with ADB's efforts to strengthen institutional capacity and governance in our member countries. We do so through our policy reform programs and through the standards we agree with you under our project financing agreements. These aim to ensure fair, transparent, and cost-effective procurement of goods and services, robust financial management, and close scrutiny of disbursements, and sound management of any assets purchased or built under the project. These standards go a long way to influence the positive change that we all aspire to as public servants with a passion for development. At the same time, we must be aware that upholding those standards requires more than trust in the honesty and integrity of the parties with whom we transact. We still see too many cases where scarce development funds are put at risk by unscrupulous or careless market players seeking to cut corners or get a leg up from the competition through fraudulent or corrupt practices in breach of our carefully designed standards. This is where deterrence and protective action through ADB's anti-corruption policy come into play. ADB has adopted and maintained a policy of zero tolerance towards fraud and corruption as long ago as 1998. Ever since, it has been vigorously investigating any allegations of fraud, corruption, or other integrity violations on ADB projects, and sanctioning any parties that have been found to have engaged in such acts. Typically, such parties may be debarred or temporarily suspended from bidding for ADB financed contracts. You will hear today about how sanctions work and the importance of checking ADB's complete sanctions list before awarding an ADB finance contract or agreeing to variations of an ADB finance contract. This is in keeping with our joint responsibility to protect funds from abuse and waste through illicit practices, to promote fair and cost-effective procurement, and to achieve the intended development impacts of our projects. Failure to conduct the appropriate checks may not only put an improperly awarded contract at risk, but may also require ADB to reconsider or even withdraw its financing for the entire project. I now hand over to today's panelists who will discuss the subject in further detail and explain what is required to mitigate these risks in more detail. Before I do so, I call upon you to also underscore in your interactions with your colleagues their responsibility to check ADB's complete sanctions list and strengthen their knowledge in sanction screening. Integrity is everybody's business. Over to you, Lily.
Thank you so much for the warm welcome, John. So we now move on to the main program to tell us about ADB debarments and suspensions of entities. Let us welcome the advisor for ADB's Office of Anti-Corruption and Integrity, Mr. David Bince. Hello, David.
Hi, Lily. Thank you very much for the welcome, and welcome everybody wherever you may be in the globe this morning, this afternoon, or this evening. In line with what John has just introduced in his welcome, of course, what you'll hear about is standards, policies, procedures, rules, regulations. And that's what governs us all through either our actions and the work that we do at ADB and of course the work that you do in relation to ADB financing through the loan agreements and the various documents. What I intend to do today as part of my 5 slides is really over the next few minutes is to give you context in what you will hear in relation to those rules and regulations that you will hear from Rustam, Jeff and Lisa in relation to their presentations. So what I want to do is give you an overview on how what we call an entity, which is a firm or an individual or sometimes referred to as a party, becomes debarred and ineligible to participate in ADB financed or ADB related activities. And this is in line with our anti-corruption policy and what we call our integrity principles and guidelines, which were last revised in 2015. And before I sort of go to what is my prime first slide, last year we had 302 complaints that we received, and 60% of the complaints we received came from external parties, which included our executing and implementing agencies. And what we've seen over the last few years is a noticeable improvement in the number of complaints or issues or concerns that we are receiving from the EAs and IAs, as we call them. And I think that's because of the improvement in the diligence that you are conducting in relation to the work that you perform in our finance. So, you know, from that significant number of 60%, you should be commended for the work that you are doing. It doesn't mean, though, that we are perfect, and there's still a lot of work to be done. And out of the complaints, whilst there are many integrity violations that we'll touch on a bit later, the majority of complaints that we do receive are in relation to fraud and collusion. And this usually is what we find or detect, or you detect in the bidding documents, because you see that there is a document that has been amended. Documents look similar across multiple or at least 2 bids. And so it's your detection that has also helped with those complaints being reviewed by ADB and then being investigated by what was my former team. So as I mentioned, there are 2 guiding documents that help us in our investigations. It's the anti-corruption and integrity, the anti-corruption policy and the integrity principles and guidelines, as I last amended in 2015. And there are literally 3 ways that an entity or a party that can be debarred or suspended by ADB. Firstly, what I need to put in perspective, and you will see from OAI, from the Office of Anti-Corruption Integrity's webpage, there is 1 point to report integrity violations, and that is to our office. We are the sole investigation function in ADB for integrity violations. And you may report any concerns that you have through that web page or directly to us through the email addresses that we provide. And in the worst case scenario, following an investigation, a firm or an individual may be debarred. At the commencement of an investigation, if there is sufficient evidence to indicate that an integrity violation has been committed, it may be in the interest of ADB and the executing agency that we act very quickly to prevent contracts from being awarded to those particular parties or entities. So at that particular stage, ADB may determine that we should enforce a temporary suspension. And the third way that we may debar or suspend an entity or party is through what we call the Agreement for Mutual Enforcement of Debarment Decisions. Now, there are 5 parties or organizations that are party to this agreement. And when they have concluded an investigation, they may submit to ADB a sanctions notice that informs us that a particular party has met the criteria to be debarred by the Asian Development Bank. And under those circumstances, we will actually debar the entity and they will be listed on our sanctions lists. Now, starting off with the consequences or the circumstances when we conduct an investigation at ADB. So again, how does a debarment take place when ADB has conducted the investigation? And for the purpose of this presentation, I'm going to focus on investigations, but the consequence is the same when there is a temporary suspension. But the temporary suspension is for a fixed and usually quite a short period of time whilst we continue our investigation. So once ADB finds that an entity has committed an integrity violation, of which you will see on your screen, there are 10 violations that are set out in the current integrity principles and guidelines, we can do one of two things. We can either propose a debarment to the entity if we find that they have cooperated during the investigation and it's very important, the and is underlined, they have accepted the findings of the investigation, i.e. they agree that there has been an integrity violation. Or the second way that we may debar an entity is when we submit our investigation to the Integrity Oversight Committee, which is a partially independent committee outside of our office to determine whether the entity should be debarred or not. Now, usually these cases are where the firms do not agree with our findings, i.e. they contest them. They fail to respond, or if they fail to respond to our correspondence with them with our findings. All those cases will have to go to our Integrity Oversight Committee to determine whether an integrity violation has been committed. And as you will see on the right-hand side, at the end of October 2021, there were 1,522 entities debarred for integrity violations against ADB, meaning this was in relation to a specific ADB-related activity. And this is quite important that I'll come to at the last slide, why this is very important. But please bear in mind, 1,522 firms and individuals currently debarred by ADB. As I mentioned earlier, ADB may debar an entity because of another MDB, Multilateral Development Bank's investigation. And the four other multilateral development banks are the African Development Bank, European Bank for Reconstruction and Development, the Inter-American Development Bank, and World Bank. That together with the Asian Development Bank, they are all parties to the AMED that I referred to earlier. And so if the criteria is met to debar an entity, then they may submit a notice to the Asian Development Bank, and we may publish their names on our sanctions list. Now, if you remember in the last slide, ADB has 10 integrity violations under which we may debar an entity. For the purposes of the cross-debarment, there are only 4 integrity violations, which are fraud, corruption, collusion, and coercion. And the reason why there are only 4 is because we have harmonized the definitions so that they are the same across each of the 5 organizations. And that's one of the conditions, that we have to have the same definition to be able to enforce the cross-debarment. And I think it's very particular. It is up to the other MDB to issue a notice to ADB for us to enforce it. Unlike a couple of other MDBs, where they will take our sanctions list and use that as their enforcement, for ADB to enforce an action, it can only come from one of these 4 development banks, and we must receive a notice. And as at the end of October 2021, there were 867 entities debarred through the cross-debarment. And you'll be pleased to know this is my final slide, and you're not going to have to hear too much from me. In light of the topic today that we're discussing, this is the most important slide in my section relating to the ADB debarments. Because of our policies, these stem back to our public disclosure policy, now our access to information policy, we are restricted in what we are permitted to publish in the public domain. Because of this, it means that 89% of the 1,522 entities that ADB has debarred are not public. They are not viewable in the public domain. All of the 867 cross-debarred entities are published, and the reason for that is they were published by the other MDBs, which is one of the criteria that must be considered for cross-debarment. Now, why is this so important? 89% of the 1522, which means that 43% of the 2,389 in total are not viewable in the public domain. And this is very important to your roles and responsibilities as the executing and implementing agencies, in that you are accessing our complete sanctions list, the sanctions list that is password protected and that you have to log into, which means that you will see the full population of the 2,389 entities that we are debarred. So when you are meeting your obligations under the loan agreement, you are checking everything, not what is on the published list only. And this is important because as one of ADB's integrity violations, there is a sanctions violation, and contracts may not be awarded to ineligible entities. In 2021, we have so far investigated 9 cases, or 9 cases are ongoing, where contracts have been awarded to ineligible firms, i.e. 9 contracts have been awarded to firms out of the 2,389 that are on our sanctions list, our complete sanctions list, which means somewhere along the line, we haven't met our standards. And so what you will hear today from Rustam, Jeff, and Lisa is how and what you need to do in relation to making sure that we are protecting our finances, as John said, and that we're only awarding contracts to entities that are eligible. So with that, I'm going to stop. Hopefully there'll be questions later on that I'll be able to answer, and I will hand it back over to Lily. Thank you very much.
Thank you for the explanation, David. And ladies and gentlemen, as David reminded you all, remember you can type in your questions at any time during the presentations. Use the Q&A box at the bottom of your screen for some, or it could be, if you're using an iPad like me, it will be at the top of your screen. Coming up next, we have 2 speakers who will discuss the responsibilities of executing and implementing agencies. Everyone, help me welcome the directors of the 2 procurement divisions of ADB's Procurement, Portfolio, and Financial Management Department, Mr. Rustam Abdukayumov and Mr. Jeff Taylor. Over to you, Rustam, and then Jeff.
Thank you very much, Lily, and a warm welcome to all our participants. So maybe let's discuss why the sanction screening is important. We will cover it from a procurement perspective, and as you have noted, David has already mentioned about ADB's anti-corruption policy and the integrity principles and the guidelines, but there are not the documents which just sit separately somewhere. There is a cross-reference to these documents in ADB's procurement policy and also in ADB's procurement regulations for ADB borrowers. And as you well know, all procurement under ADB finance project has to be done in compliance with ADB's procurement policy and the procurement regulations. So the procurement policy makes a cross-reference to ADB's anti-corruption policy and integrity principles, and basically requires that all participants in the bidding process, in the procurement process, apply the highest standards of ethics, right? And the procurement regulations for borrowers, which are basically a guidance for all borrowers in implementation of ADB funded projects, clearly states that the individuals or firms who are sanctioned or temporarily suspended by ADB are not eligible, neither to participate in the tendering process, nor to be awarded the contract directly, nor to benefit from any contract which is financed by ADB. So all this is also translated into financing agreements. Many of you are familiar that we have loan agreements or grant agreements, and there is a clear reference to ADB's procurement policy with respect to undertaking procurement and the procurement regulations. And of course, there is a clear statement about the eligibility requirements. So these provisions are reflected not only in the loan and grant agreements, but also in the standard bidding documents and requests for proposals which are used by ADB. By the way, if in case not ADB standard bidding documents are used, but used maybe contracts from other internationally acceptable organizations, those provisions related to anti-corruption and integrity will have to be incorporated. So if we look at the standard bidding documents, there is information about anti-corruption in the instructions to bidders in section 1. Then more importantly, in section 3, which is evaluation and qualification criteria, there is a clear statement about ADB eligibility and the UN eligibility, which we will discuss a bit later. And also in the letters of bid, bidders are required to disclose whether they had been sanctioned or debarred or temporarily suspended. And also very important, in all contracts, there is a similar provision on anti-corruption and integrity, whether it is contracts for supply of goods, civil works, or for consulting services. So we basically require executing agencies to check all these important provisions at different stages of the procurement cycle. So let's discuss in more detail about that. And if we can move to the next slide. So these are the steps in procurement of goods and works and procurement of consulting services. They're quite similar, but there are some differences. And if we start with the procurement of goods and works, we see the first stage is pre-qualification. It is not a mandatory, but sometimes if executing agencies prefer to use pre-qualification to identify potential bidders, this sanction screening will have to be applied starting from pre-qualification. So all provisions related to anti-corruption and integrity will have to be reflected in the documents for application for pre-qualification. If pre-qualification is not used, then of course the very first step is the preparation of the bidding documents, which will have to reflect all these requirements that we have discussed. And the first stage would be, of course, depending on the type of procurement method used, whether it is single stage or one envelope or two envelope, there could be one evaluation report submitted by the executing agency, or could be two evaluation reports, technical and financial separately. But if there are two reports, then it means at the stage of technical evaluation, EEAs are required to check against the sanctions all bidders who submitted their bids, right? Because it's still not known who is the winning bidder. So therefore, we all have to ensure that all bidders who have submitted bids there are eligible. Then some bidders may not be qualified to the next step, and so the number of bidders at the financial evaluation could be less, but still the same process will have to be done at the financial bid evaluation. The reason is because the time gap between finalization of a technical BER and ADB's no objection and the financial BER could be quite long, and anything could happen during that process. And therefore, we all have to ensure that there are no sanctioned entities who are participating in the tender. Then, of course, the next step is the contract award. Again, ADB may issue a no objection to contract award, but actual contract award may happen, and the notification for contract award may be issued at a much later stage. On average, it takes 2 months, although our requirement in the standard bidding documents is 28 days. For different reasons, there are delays in issuance of notification of award. But then, of course, before issuing this notification, EEAs will have to check again whether the entity which is intended for contract award is not under sanction list. And then, of course, during contract implementation, contractors or suppliers or service providers will be submitting withdrawal applications. And although they may have been checked against sanctioned list at the contract award and there were no issues with that, at the time of payment, also there should be very kind of clear assessment of whether these contractors or suppliers are under sanctioned list or not, because requirement for sanction screening applies not only at the bidding and contract award stage, but also at the contract implementation, because ADB cannot finance the services provided by sanctioned entity. And of course, during contract modifications and variations, similar check will have to be done. If we consider consulting services, the number of stages is similar, but they're slightly different because unlike pre-qualification, shortlisting is mandatory. I'm talking about recruitment of consulting firms. Right? Those of you who are familiar and working with ADB for quite some time, perhaps you are familiar with the submission 1, 2, 3, which goes to ADB. It comes to our procurement department, and we will have to issue an objection before moving to the next step. And these actually submissions 1, 2, 3 relates to the shortlisting, technical proposal evaluation, and then final ranking and contract award. So it's also very important from all the long list of entities who submitted expressions of interest in the preparation of the short list, executing agencies will have to review not only the past experience of all these firms, but also check whether they have been sanctioned or not, or even temporarily suspended. Then, of course, similarly, with the procurement of goods and works, similar check will have to be done at the technical proposal evaluation, financial proposals, and contract award. Again, the main reason is that between these steps, there could be sufficient time gap, and there could be many things happening with those who have been shortlisted or basically those who pass technical evaluation. So therefore, this is very important. And again, similar to procurement of goods and works, at the stage of withdrawal applications and the contract modifications, similar checks will have to be done. Now let's focus on how EEAs should undertake this sanction screening. Of course, we all are aware that executing and implementing agencies normally have a team of procurement professionals who are responsible for undertaking procurement and preparing bid evaluation reports. So they are responsible for reviewing bids, right? So of course, it may differ from one executing agency to another, but in many cases, there are dedicated staff within the procurement team who are responsible for sanction screening. So one first step is to check all bidders against the UN Security Council sanction list. That list is published, it's publicly available, and then it's basically to check whether any of the bidders who submitted bids are in that sanction list. Another very important step is to check against ADB sanction list. And as David also mentioned, ADB has its own sanction list, and executing agencies can be provided access to that list. And once they have been provided access, again, someone from the procurement team will have to check against the ADB's sanction list. Once the sanction checking or screening is completed, it's very important to reflect this in the bid evaluation reports which are submitted to ADB. Because ADB's duty is to review bid evaluation reports submitted by the executing agencies and whether support the recommendation or not. Part of that is always about the eligibility of bidders, whether it is at the technical evaluation or final recommendation for contract award. We will have to ensure that there are no entities which are sanctioned. So this is one requirement to reflect these results of the sanction screening in the bid evaluation reports. However, there are cases when there is no bid evaluation report. There is a direct request from the executing agency to ADB to approve a direct contract. In this case, that request, which justifies the reason why it is important to directly award the contract to a particular entity, the same request will have to indicate that the sanction screening has been conducted and the results basically indicate that the entity which is recommended for direct contract award is not in the ADB sanction. So this will have to be submitted to ADB, and based on that, ADB will make its final determination. So in short, I think it's very important for all executing agencies to clearly define the roles and functions of procurement professionals in their project implementation units so that they're aware who is responsible for sanction screening, and those who are responsible, if they do it on a regular basis, they will be familiarized with the process, with all the tools, and it will be much easier and quicker for them to go through those sanction screening. I would like to now hand over to my colleague Jeff, who will talk about some special considerations and, more importantly, what are the risks to our executing and implementing agencies in case the contract is awarded to a sanctioned entity. Thank you, and back to Lily.
Yeah, thank you, Rustam, much appreciated. And hello, everybody, whatever time it may be for you, thank you for joining us. The special considerations mentioned by Rustam that we have is under post-review sampling, the executing agency remains responsible and is the front and single line responsible for conducting sanction screening at all stages of the procurement process before signing the contract. I'll go on to why this is important. Essentially, the first knowledge of that ADB will have of the contract's existence is when we receive a signed copy. And if we receive a signed copy of a contract with a sanctioned entity, in all probability, we will be unable to finance it, leaving an EA and a borrower with an obligation to pay for a contract or the exit of a contract for which ADB will be unable to finance. So it is a very important issue, especially as we want to move to more efficient and trusting procurement review processes to lower the transaction costs for all of our borrowers and for ADB, and to speed up implementation. The second area is non-sovereign operations. Our anti-corruption policies apply equally to sovereign and non-sovereign. So in these, ADB requires borrowers to demonstrate that procurement was transparent, preferably conducted through competitive bidding. But the important issue here is that the EA must also confirm that the contracted entities are not on ADB's sanctions list. It says OAIs on the slide, but it's actually ADB's sanctions list. OAI represent ADB as a whole in this area. And additionally, when ADB is participating in financing PPP transactions, entities on ADB sanctions list are not eligible to become project sponsors. The risks to EAs. If an EA fails to conduct the required sanction screening at various stages, as pointed out by Rustam, before the contract is awarded, and the first rank bidder is found to be debarred or temporarily suspended, ADB will be unable to issue a no objection to the contract award recommendation. That would require the borrower potentially either to go to the second ranked bidder or to actually restart the whole procurement process at significant cost and significant delay. If an EA has awarded and signed a contract with a debarred or temporary suspended and ineligible entity, ADB will have to take appropriate action, potentially including declaring misprocurement. Rustam pointed out earlier in the presentation, 3 slides ago, that a sanctioned entity is ineligible to receive an award of contract with ADB financing. That means, as said here, that we may be forced into a declaration of misprocurement and non-compliance with ADB's procurement policy and regulations, and could lead to the cancelling of financing for that contract package. In the worst case scenario, it could lead to cancellation of a loan, but I have not seen that. But I have seen a number of cases where we have received contracts awarded to ineligible entities that we have been unable to finance. This represents both a reputational risk and a contractual risk to EAs, as contractors will still be under contract, and the obligations under that contract, unless there has been a misrepresentation in it, will require that contract to survive regardless of whether ADB financing is in place or not. So that can place a significant obligation on the EA's own financing and own funds outside of ADB's, because ADB financing cannot be used. Contractors can terminate contracts for cause when funding is not available, and they can be entitled to claim financing charges under delayed payment provisions in such cases. So it is very, very important that all EAs ensure, both in prior review, post-review, and post-review sampling, that it undertakes sanctions checks. And Lisa, who's coming next, would explain more about the platforms provided for that. That concludes the presentation from me, and I look forward to the question and answer session later on in the session. Thank you very much.
At this point, let us find out how sanction screening work and why they are important for us. Please welcome the Director for Prevention and Compliance of ADB's Office of Anti-Corruption and Integrity, Lisa Killart-Courtney. She will also lead us through the key findings and takeaways, as well as the question and answer session after this. Wonderful to see you, Lisa.
Thank you so much, Lily, and good afternoon, good evening, good morning, everyone. So as Jeff and Rustam have just highlighted, there are 2 sanctions obligations on executing and implementing agencies. They are to scrutinise the ADB complete sanctions list and also check for any sanctions issued by the United Nations Security Council. So let's have a little bit more of a look at ADB sanctions. To give you an idea of where some of these risks lie, this year the Office of Anti-Corruption and Integrity undertook some sample testing of 37 projects, and these were existing projects with live contracts. Of those 37 projects, 77 had executing agencies and implementing agencies engaged. On checking whether they had access to the complete sanctions list, worryingly, only 16% had access to the complete sanctions list. So that tells us straight away that the sanctions checking is not being done through the complete sanctions list. More concerning is, of those 77 executing and implementing agencies, 13 of those were also engaged in other ADB projects. So that means that there was no access to be able to do the sanctions check, and they were responsible for multiple projects. From the beginning of 2021 to current, resonating with David's message of ongoing investigations, is that a contract should not be awarded to an entity or an individual that is subject to an ADB debarment or temporary suspension. At the moment, we have over 28 cases of potential debarment condition breaches that have been detected and that are being considered for investigation. They range across multiple industries, whether it be agriculture, education, transport, energy, urban, or water. And they are also scattered across all of ADB's regions, through the Pacific to the South Asia, Southeast Asia, Central and West Asia, and East Asia. So these numbers were compiled for this presentation. The numbers were indicating 28, but as of today, the numbers that have been escalated for potential investigation now stand at 33. So it is really important to undertake the sanctions checking to ensure that contracts are awarded to eligible individuals and firms. So how to get access to ADB's complete sanctions list? When you go to the website, you will see two distinct areas. One is the published list, which is accessible to the public worldwide, and then one is access to the complete list. It is password protected and it is accessible by our board of directors, ADB staff and consultants, and parties on a need-to-know basis, including executing agencies and implementing agencies. So how do you get access? So there is a sign up button, and you click on the sign up button and it will take you to a form. If you are having issues clicking through and getting to the online form, under the sign up button is also a hyperlink where there is a manual form available that you can download. It asks exactly the same information and it can be submitted by email to integrity@adb.org. So there's two options. There is through the online portal, or you can download the same form and submit. So as you will see, this is the actual form in this slide. It asks questions that you would expect to see. Your first name, middle name, last name, because you will be representing an executing agency or an implementing agency. It will ask you for a username and a unique password. Just like any online platform, please be careful and make sure you practice full internet security, especially when selecting a password. Please do not share that password. It should be unique to you. Make sure you complete what your designation is and the organisation or agency that you belong to. You will see red asterisks in the form, and they are the compulsory fields that you need to complete. It is also very critical that you fill in the name of the ADB project officer, ADB project officer and their email address, because we as in OAI, we then can verify with the project officer your involvement in the project. So the form is very, very straightforward. Please make sure it's fully completed. As I said, if you cannot fill out the form online, you can download the form. It's going to ask you exactly the same information and you can email it in. When you do it online, you will receive this message, and that is that your registration has been successfully submitted, and you will receive an email after the approval process. Now, excuse me, more than one individual from an EA or IA can apply, and we would highly recommend that. People go on holiday, people move jobs, and there's definitely going to be more than one person involved in the procurement process. So if you need to help your colleagues to walk them through that may not be present at today's session, please re-emphasize their responsibility to sign up to the ADB Complete Sanctions list and make sure that the list is scrutinized. So make sure as an EA or an IA, you designate the appropriate persons from the agency that require the access on a need-to-know basis. ADB does not dictate your governance structure on who should access the portal. That is up to the organisational controls you have internally as an executing agency or an implementing agency. Please, it is like anything online. Do not share accounts. Do not share user account names or passwords. Each user must apply for a unique user ID. Again, as I emphasized before, please make sure that you submit full, detailed, accurate information that allows the user ID to be identified to a single user. If your role changes, inform ADB or the ADB project officer if the user profiles have changed since the initial request, or it may actually require deactivation. So access may no longer be required, or the user may no longer be connected with the EA. So a manager can contact us and say that one of the staff members of an EA or IA has left, and we will deactivate that account. So this is how you use the complete sanctions list. So I have intentionally used Vietnam as an example because it is spelled as 2 words, not 1 word. So when you're searching, make sure that you're using what we call as search logic. So if you're putting in PRC, you may not get a hit. Please make sure that you don't just do a search and walk away. Make sure that the search is complete. If you were searching for Vietnam, you would literally put that in the search function and you would click the blue button which says go. It will then bring up all the firms that are domiciled in Vietnam that are sanctioned by ADB or recognised under our cross-debarment agreements as David iterated at the beginning. And it will tell you that they're debarred, how long they're debarred for, and what they're debarred for. It's okay if you don't understand the guidelines and 2.A and 2.A section 2. The important thing is that the screening is undertaken. If they're barred, do not engage. You can also use name searches. If you're using name searches, and I've put an example here, you go to the search function again. You type in, say, if you're searching for A2Z engineering. Please go to A2Z. If you go to engineering, you will get a lot of hits. And if you're very patient, that's fine. But if it's got a unique characteristic like A2Z, please just use that. So type the search name in the bar. Avoid common terms such as LTD, LLC, M-S. And this example is that I've typed in is A2Z when searching for A2Z waste management. And you will see for A2Z, it has come up with a number of hits. We've got, we have 7 on the screen, and it will show you the country that it is debarred, how long it's debarred for, etc. Now, if what you're searching comes up with a message like this, it's a non-ADB member country, it is still debarred in the eyes of ADB, which means that it cannot be shortlisted for a bid. It will say whether it's cross-debarred by the World Bank or the European Bank of Reconstruction Development, etc. That is fine. But if it's still debarred, it is debarred. As Rostam also highlighted, one of the other obligations you have as an executing or implementing agency is to check for the United Nations Security Council sanctions screening. So you go to the public website of the United Nations Security Council. It doesn't need a login. It doesn't need a password. The search function is available in 6 languages. You can choose those languages from the top right toolbar. When you go to the United Nations Security Council sanctions page, you will see a search function, and it basically says search UN Security Council consolidated lists. That is really important to use that because there is multiple lists, and excuse me, this is where the list is consolidated. For the United Nations search, it is again fairly straightforward. You can choose the language of the search and you can put in keywords that you wish to search and hit the search key. The United Nations website, the same search function, also has an advanced search methodology. You can put in keywords, you can put in words you wish to exclude. You can also put in dates of birth for individuals. So those options are there for the UN Security Council sanctions screening. So I've walked you through some of the key findings that ADB has just for this year, that we have many executing agencies and implementing agencies that have never requested access to the full ADB complete sanctions list. I've also highlighted the number of suspected breaches we've had this year, and that they are now with our investigations function to take forward. Jeff and Rostam highlighted also the impact that if it is found that these entities have or individuals have been awarded contracts while debarred, that the risk is quite high to an executing and implementing agency by way of operational and reputational risk, including the risk of misprocurement. So on that note, we will now open the floor to Q&A, and I will go to some of the, we've been asked by quite a number of people, can we share the presentation material? As mentioned at the beginning by Lily, the material will be available on our Knowledge Events website within a few days in English. Lily, may I ask, will we be sharing with everybody that has registered, will we be sharing the link to the Knowledge Events platform?
Yes, Lisa, we will be posting that there right now. It's already on the chat box, the link to the webpage where all the resources will be uploaded in a few days.
Great, thank you. So if everybody would like to save that link and come back in a few days, it will be available. Some of the other common questions we've got is how to obtain access to the complete ADB sanctions list. We've just walked you through that. If you need further assistance, please do not hesitate to reach out to your project officer. But as I said, it is fairly simple to get access to the complete sanctions list. What's really important is that you do get access to the complete sanctions list and you do the screening at all those stages that Jeff and Rustam highlighted. May I please pose a question to Jeff that we have in the chat box, Jeff or Rostam? If immediately after signing of the contract, the contractor falls into the ADB sanctions list, will the contract with this contractor be nullified? And if so, how?
Not necessarily. It's the eligibility is at the time of submission of a bid or proposal, running through to the actual contract award. However, if the offence for which the entity is being sanctioned relates to the contract just awarded, you would have the right as an EA under the contract to terminate for cause, because there has been a breach of ADB's anti-corruption policy in the submission of that bid or proposal. And all of our standard forms of contract allow an EA to terminate for cause in such circumstance.
Thank you very much, Jeff.
Sorry, I just had my hand raised, Lisa. Sorry, it's actually about an erratum in my presentation, where I stated that 57% are on the published list, where it's actually 43% and 50% of the debarments are unchecked. So it is actually a worse case for what is published. And I just wanted to make sure that everybody is aware of that, because the mathematicians have been sending messages to me that I've got my maths wrong.
Thank you, David. And Jeff, you've raised your hand as well.
There's a very good question in the Q&A from Ralph, which I would like to respond to, which is, I'll read it for everybody. How do we as consultants get access to the sanctions list in order to make sure that any possible partner, firm, joint venture partner, or sub-consultant are not debarred? Currently, you would be unable to access that sanctions list. So what I recommend as part of your own due diligence, because anyone who is sanctioned has a right to reply, has been investigated. So I would simply recommend that you ask any firm or individual that you intend associating with, have you been sanctioned by ADB? Ask them to make the same declaration that EAs require bidders and consultants to make. So my recommendation, Ralph, is you ask the question directly of anyone that you intend associating with.
Yeah, may I just further Jeff's point on that? Rather than just asking, make sure that it is documented, that you've followed those procedures, that there is a form of certification or notification, one, that you've asked the question, and two, that they have responded in the affirmative that they are not debarred, and that is why you are submitting them as part of your bid or as a JV partner. You know, if you ask the question but have no evidence, of course, it may be more difficult for you to substantiate that when we conduct an investigation, if there were to be an issue.
Yeah, very good point, David. And you could look to, in consulting, you could look to the standard declarations that ADB require the consultants to submit as part of their proposal and ask for exactly the same. That the individual or the entity certify that it is not sanctioned by ADB. And of course, you'd also be interested as to have they been sanctioned by any other entity, not just ADB.
Thank you very much, David and Jeff. We have another question, which is a very good one. And it is, how do we know if the sanctioned firms change their name and submit bid documents? Now, the ADB sanctions, and I'm sure David will also jump in here too, please. The ADB sanctions, when a sanction is implemented, it also applies, excuse me, it also applies more widely. So even if the owner of a firm is not individually mentioned, they cannot hide behind a corporate veil and set up new companies to circumvent a sanction. David, would you like to add to that?
Yeah, I mean, this is more about the change of name, I think is the question. Is that correct?
Sorry, the question is, how do we know if the sanctions firms change their name and submit bid documents?
Yeah, I mean, that's very difficult because that would be a circumvention of the debarment if they were not to notify ADB of the change of name, because there are legitimate reasons for changing names. But if a firm is debarred by the Asian Development Bank, at the time that the firm changes its name, which would be a legal process, they are supposed to inform ADB. If in their bidding documents they use the new name and do not refer to the old name, it would be very difficult for you as the EAs or the IAs to know that, that it's a debarred entity. And we hope through our processes that would be captured. It's one of those, it's difficult, and there cannot be an expectation all the time that every single debarment, if this was to happen, that you are expected to catch it. There are some that will get through the gap. You know, one of the things that may be, of course, important is when you look at the prior work experience. The prior work experience cannot obviously be in the name of the firm when the firm's name has recently changed. So I would say, as an indicator, what you may need to look out for when a firm has bid, the registration is recent, please look at the work history. And if the work history is showing that firm's name prior to the date it was registered, there is a red flag that you should investigate and request for further information.
Thank you, David. Another question, and I'll read it out for everybody. The question is, can no financial transaction be done with a sanctioned entity? What should be done in the case of a proprietary technology / product of a sanctioned party that has to be used in a project? So if I could lead with that, a sanctioned entity should not be awarded, should not be shortlisted and awarded any contract in related to an ADB project. So if it becomes debarred during the period of a contract, ADB tends to allow as a whole for that contract to continue, and therefore it doesn't have an impact on financial payments to that contractor. However, if there is any modification, extension, or variation of the contract, the IAs and EAs must undertake sanction screening at that point. And if it's detected that they have become sanctioned, then ADB must be advised immediately, and that is to ensure that any modification, extension, or variation is not used to try and circumvent the debarment or suspension in place. David, did you want to add to that?
Nope, that's fine by me.
Thank you. We do have a question, David, in for you, please, in relation to the reinstatement procedure. I'll read the question for you. If it has been agreed between the sanctioned entity and ADB that upon receipt of a request for reinstatement, OAI may require independent verification to determine a debarred entity's suitability for reinstatement, does that mean OAI may decide not to require independent verification? And the second part of the question is, may the debarred entity or its counsel demonstrate the effectiveness of its ICP without hiring an independent evaluator?
Yeah, in the conditions, and I apologize for the sirens going off in the background. in the conditions that we will state as part of the debarment notice, we will set out whether a monitor is required or whether an independent third party is required to demonstrate the effectiveness. If it is not stipulated in the conditions, then it is really just down to the entity and or their counsel to demonstrate to us that they have implemented certain controls within that particular ICP. So again, that really also goes back to the first question. When it says may require independent verification, if there are any doubts in relation to what is being stated to us in response to the reinstatement request, we may seek independent verification because we doubt or we have information that certain policies have not been implemented. So we do have that right. If we deny a reinstatement on that basis, we would have to go to our Integrity Oversight Committee and give the reason why we are denying the reinstatement. And then the Integrity Oversight Committee will either have to agree with us or deny that request, and a firm could be reinstated without the verification. I hope that answers your question.
Thank you very much. David, I believe another question for you. In the case of the debarment of a parent company, are the subsidiaries eligible for bidding or contract award?
So, when we debar an entity, certainly a parent company, we actually will debar the subsidiaries, the affiliates, the associates of that particular company. Now, in certain circumstances, we do not know the names of all the branches, subsidiaries, etc. And therefore, when we issue the notice, we are unable to put the names of those subsidiaries and similar firms onto our debarment list or onto the sanctions list. So again, this is a question that we've had in the past. It is then very difficult for the EAs and the IAs to establish that a subsidiary is linked to a debarred entity. But unfortunately, certainly in contested cases or contested investigations and contested debarments, we just do not have the access to all the information. But generally, if the parent is debarred, so are the subsidiaries, and the subsidiaries are basically those that are owned and or controlled by the parent.
Thank you very much, David. So we have another question where if a contractor was debarred for a limited period after contract award, how are contract variations to be managed during the debarment period? As I mentioned before, in relation to any contract variation, modification, or extension, when it relates to a contractor, whether it's an individual or a firm that is debarred or under temporary suspension, then the Office of Anti-Corruption and Integrity is to be contacted, and we will analyse the risks and the controls in relation to that variation, modification or extension to ensure that it is not being utilised to circumvent the sanction in place. David, Jeff, I think this could be a joint question. Does ADB have any methodology to put sanctions on an executing agency?
Should I go first, David, or you?
You can go first because you'll probably answer it.
Okay. ADB's anti-corruption policy does not apply directly to EA staff and their behaviour, but it is certainly something that we would have a discussion with the borrower. And we do actually have multiple sanctions under our financing agreements and articles of ADB's charter about how ADB finance projects are administered. So it would not necessarily be through the steps and processes we have been describing here. But I mean, ultimately, ADB's most extreme sanction in this respect would be accelerated repayment of the entire loan and the cancellation of the outstanding amount in the most egregious cases. Seldom, if ever, done, to my knowledge, although I haven't been at ADB for 56 years. But I have seen loan cancellation where there have been performance issues in that. But it doesn't fall under the ambit of what we have been discussing here. David?
No, Jeff is correct. Now, the closest we get as part of an investigation, of course, is if we identify individuals within an executing agency that are involved in any misconduct or any integrity violation. We have the right to refer the matters, and that there are two ways. We can actually report this to the executing agency itself to take action and review the issues that we inform them of, or we have the ability to refer the matters if we feel it's particularly egregious and in breach of a criminal law, would be to refer the matter to the national authorities of that country. But from an ADB sanction perspective, Jeff has covered what we may do in relation to the loan, and possibly we may suspend any future financing until we have a resolution. And when I say further financing, with that particular executing agency.
Thank you. So we have other remedies. It may not be, it is not an ADB sanction, but ADB has other remedies in relation to integrity misconduct by EA or IA. David, there's a follow-up question for you, if I may, please. It says, regarding a previous question, I understand the answer is that OAI has the right to reject a reinstatement request on the basis that there is no independent evaluation. They are asking, is their interpretation correct, please?
Yeah, it's not necessarily the fact there is no independent evaluation. OAI or ADB may be in possession of other information as to why the conditions that a firm or an individual is stating that they have complied with or have put forward is inaccurate. And therefore, we may request an independent evaluation for that to be confirmed, or we may, on the basis of the information we have, just request that there is no independent evaluation and just reject the reinstatement by submitting the rejection to the Integrity Oversight Committee.
Thank you very much, David. I am going to ask, there is 2 questions in the chat box. I believe the language is Russian. If I could please ask the Russian translator to go to, the Q&A box, and please translate those for us so we would be able to respond accordingly, please.
Yeah, there is, I see a question from Alice from Jian PMO in Jiangxi province. I'm not going to try and answer that because I don't know the specific details of the transaction, and it would probably be wrong to discuss a transaction on this platform. But as a general issue, as we've touched on before, the contract normally, unless the corrupt act was in part committed to securing that contract, the contract itself normally continues and survives if a contractor is sanctioned after it wins a contract. So I'm not going to try and answer the question about the specific contract and ADB's refusal to remit funds without knowing further detail or in this forum. But by all means, follow up with ADB's project officer on this issue to get better clarity.
David, I believe this question may be for you, please. It says, checking the ADB sanctions list, the attendee has noted that the firm that is debarred is cross-debarred by another MDB. In this instance, it's a European Bank of Reconstruction and Development. And asking for firms data from EBRD, it should take 28 days to get the response, and they did not receive a reply. Because some firms can have the same names, but their TINs or certificate numbers are different, etc. How to ensure that they identify it. So I can probably help with some of this as well. Thank you very much for this question. A lot of this comes down to due diligence. What is available in the public forum? There is quite often a lot of information that is available. There is company registries that you may be able to utilize to validate that the company you're looking at is that same entity. David, is there anything else you wanted to add to that?
It's a very good point. And again, I look at some of the old debarments and the lack of information that there are. Is that sometimes there is just a name, and it's a very common name. And as an EA and IA, it must be extremely difficult when you're doing your evaluations and you come across these names. In this particular circumstance, I would suggest that you contact either the EBRD or ADB with the details, and we can see how we're able to assist. But the general perspective is now we're trying to provide more information with the tax identification numbers, dates of birth, up-to-date addresses. But as you can appreciate, old debarments or investigations into cases that are relatively old, addresses change, registered officers are not operational officers, and they change quite frequently. But we are trying to put more information in so that the firms and individuals can be better identified. And if there is a doubt, and I apologize on the 28 days for the response, but they would need to check all the information. And if it's with EBRD, they would need to check with us before giving a response to you.
Thank you very much, David. So some of the translated questions are starting to come through. So one of the questions was, if a company is in the sanctions list, but bids in the name of another company that is not in the sanctions list, what should we do in this case? That is a very, very good question. And we would consider that actually as a potential breach of sanction conditions. So if they've been identified from their previous work experience, that the work experience is not in the current name of the bidding company, that is a red flag, and or references, etc., maybe in or bank account details are not in the name of the bidding company. They can also be flags that could indicate that the company has been set up to circumvent a breach, a current sanction. Apologies, a current sanction, and so the new company may not be in the sanctions list, but ADB would take that quite seriously, because that is even worse. That would be an intentional act to circumvent ADB debarments and suspensions. Please bear with me because these are not in the chat box. I'm getting them directly from the translators. How to identify owners if they are not in any official documents, but there are suspicions that they are beneficiaries of specific persons. David, can I read that back again, please? How to identify owners if they are not in official documents, but there are suspicions that they are beneficiaries of specific persons, probably specific companies. So it's the due diligence challenge that we all face again, isn't it? And the ADB sanctions list is one tool, but there may be a lot of other publicly available data, whether it's company registries, such as that may indicate ownership. But some ownership I think we all recognise can be very, very complex to identify ultimate beneficial ownership.
In terms of the sanctions, if there was any suspicion that these are sanctioned entities or individuals, it would fall basically under the procurement guidelines as to what can be requested from the firm. So I'll ask Jeff to interject. But if there are suspicions, then I believe that the EA may ask further questions in relation to the bidding documents that would be relevant to the eligibility for ADB. Yeah.
Yeah, thank you, David. I mean that almost sincerely, not most sincerely. Beneficial ownership, as Lisa has pointed out, is a problematic area for all financing institutions and MDBs. And where does beneficial ownership actually extend to control over a company? We have to remember the legal person making the bid is the bidding company. And if we look at the global companies, they will have hundreds of thousands, if not millions, of beneficial owners, every single shareholder. With SMEs and smaller companies, what we've seen and what we've found is it's generally more possible to identify the beneficial owner because they're often an executive of the company as well. And the sanctioning would apply to them as an individual, their firm, and any other firm that they're associated with. But it is possible, and there are many registrations that are actually set up in various countries to cloud the issue of beneficial ownership or ultimate ownership of companies, property, and so forth, making it a significant challenge. But with the smaller companies where I've seen it, the sanction would normally extend to the current beneficial owner of that company, the CEO as well, and any other company they're associated with. It gets harder as the companies get bigger, for sure, to identify the beneficial owners. But it is something that does get looked at in terms of when we are considering a sanction. But it's not an easy area, certainly. And it's a good question.
Yeah,
David?
Sorry, Jeff, if there are suspicions that the owner or directors of a firm are sanctioned individuals or entities, but it cannot be obtained through the registries, or the registries do not have such data, that can be reported to OAI for us to review and assess whether there may be ownership concerns through the sanctioned entities. So you, again, if there are concerns, you can refer it to us.
Thank you, David. That's thank you, Jeff and David. But that's a very good point to wrap up that question with, David. That it can be referred to us. I have a question, I believe, David, this would be specifically for you. If you could just please summarize again what criteria the fall falls under to, under what criteria the firm falls under the ADB sanctions. So we have corruption, fraud, collusion.
Well, there are 10 integrity violations in themselves that we would consider, that ADB consider. And you're right, fraud, corruption, collusion, coercion. We have conflicts of interest. We have abuse of ADB assets, which is, I think the most general one is theft. We have obstruction of an OAI or an ADB investigation. We have retaliation by a firm against somebody who may have provided information to ADB that results in an investigation. And then we have the sanctions violation itself. So a firm or individual that submits a bid whilst debarred, that is a sanctions violation. And then we have a more general, as our last integrity violation, is the failure to adhere to the highest ethical standards, which covered a multitude of sins.
Thank you.
Ethical standards aren't sins, David. They're good things.
Thank you. Thank you. Thank you very much. So the second question from the gentleman is, if we made a contract with a firm and we've been working and everything's been working really well, but later some of their activities are found to be in the list of ADB sanctions, what should we do in this case? So the first is to report to integrity at adb.org. We also have an online platform. So the integrity at adb.org is the email address. We have an online platform as well where these matters can be raised, and we also have the ability where it can be undertaken anonymously. David, would you like to add to that?
You're spot on, basically. Reporting it, especially, of course, if you have been working with them on ADB projects, it's extremely important that you let us know. And again, from your sake, depending on your due diligence, the role that the firm has played in relation to what the sanctionable practices may be, of course, ADB will take that into consideration when we conduct our investigation. But we do look at the party or the entity that has committed the integrity violation, and then we just look at the association to see whether there is any what we call culpability or responsibility.
Thank you very much. Sorry, Jeff?
Yeah, there's a nice question in here, or an interesting question from an anonymous attendee. Thanks for the presentation. I wonder why there is not a settlement option before a debarment decision is made by ADB. And I'm reading that to say, well, what about imposing a fine or a financial penalty? And ineligibility, I think, is the appropriate penalty for ADB financing. You don't buy yourself out of a bad act in most cases. And I think it is the correct penalty. But David, I will hand over to you for a fuller answer as to why, you know, the SEC and the EU spring to mind, who impose significant fines, but it's not our operating model. Over to you, David.
It's not. We don't impose fines, but we may seek restitution. And I mentioned the abuse of ADB assets, which could be theft. Part of a consideration of any action that we take would be restitution of the funds that were stolen. However, of course, theft, there is, you know, it's still an integrity violation. So we have what we call remedial actions that aren't necessarily debarments, depending on the level of the integrity violation, the type of violation. And so there could be some form of financial remedy. There could be some other remedy. There may be a reprimand. And probably the closest thing that we come to in terms of settlements, because settlements often do end up with a debarment. It might be a bit of a misconception that a settlement doesn't result in a debarment. Many settlements actually result in debarments. We have what we call proposed debarments. That's where the cooperation, which would be very similar to a settlement, the cooperation is very good between the respondent to our inquiries and our investigators, and that we would propose a period of debarment that may be short, depending on the mitigating circumstances. It might be quite extensive, despite the cooperation, because there are also aggravating circumstances. But that's the closest that we have to a settlement, is the proposed debarment. But we also have a conditional non-debarment, where the age of the offence may be quite old. The actions that the firm has taken to remediate all of the issues have been significant. There may have been a change in personnel, change of ownership, and we consider that just having them continue with their compliance program keeps them in check rather than debarring. So these are the considerations that we have when we conduct an investigation. And it is always favorable where we get very, very positive and affirmative cooperation from firms.
Thank you very much. And I'm sure that's a very well-rounded response to the question. Another question, please. Can an executive agency create and use its own blacklist? If yes, can this blacklist be merged with the ADB complete sanctions list?
I'll start on this, David, and maybe you finish. This is quite a common request. And one of the significant challenges we have in ADB's potential recognition is many of the blacklists we see are not grounded in anti-corruption or corruption that we can hold entities ineligible for, but they go to contractual non-performance or disputes and so forth. So most of the times, I have seen agency level blacklists, they have been for contractual issues rather than the issues that we've been discussing here. And we cannot, as ADB, hold somebody ineligible other than the conditions that we have agreed with our board of directors and board of governors in ADB's charter. And the two that we have are breach of ADB's anti-corruption policy and sanctioning, and ineligible by the United Nations. So we're actually constrained in how far we can go in the recognition of any other sanctions list. Obviously cross-debarment, but that was approved by ADB's board as well, had to be. So each and every time we would consider a national level or an EA level blacklist, we would have to go to ADB's board of directors and get their approval on it. And that simply is not a viable option given the structure and the transaction costs for that for ADB. But I'll hand over to David now, maybe for a fuller or more nuanced response from OAI's perspective.
No, I mean, Jeff, your response is accurate, and I wouldn't have been able to answer it any better than you.
I think to add to that, though, that if an executing agency wishes to create its own list, a control list, that would be up to an executing agency for its own parameters. That would not be in relation to an ADB requirement.
But the other challenge inherent with that is, as David has mentioned, we have very specific definitions of
Yes.
what is prohibited. So unless those definitions were aligned, we would have significant challenge in recognizing it as ADB.
That's right. So the question, though, was can an executing agency create and use its own list, not whether ADB would recognize an executing agency's list.
And merged with ADB's, it said at the end, Lisa.
Oh yes, and how can the list be merged with ADB's list?
So it would be a challenge for us.
Yes, it would be. We do have other questions still coming in Russian. If I could kindly ask the interpreter to look at those questions, please, and send through the English translation, that would be appreciated. David, question for you, please, that's just come through. What is the minimum debarment period, please?
It's a good question. The minimum debarment period that we start our debarments off at are 3 years. And that was agreed among the multilateral development banks. But 3 years may be what we call mitigated down or aggravated upwards. So we start at 3 years, but as I mentioned earlier, if you have a very cooperative firm that's providing information that helps with the investigation, we may reduce the period of debarment and it could be any period, 6 months, 3 months, 9 months, a year, 18 months. And then we look at all of the circumstances, both mitigating and aggravating, when we come to our conclusion to determine how long that debarment period is. So for a first offence, we look at 3 years minimum. And then we've actually put into our integrity principles and guidelines maximum periods for second and third offences that we would put in for firms. Now, individuals, it's slightly different. Again, the minimum debarment period is technically 3 years, but any time we may debar an individual indefinitely. And again, we would look at the type of case, the type of integrity violations, whether they're multiple, whether they're over a period of time, whether they were sophisticated. And on that basis, we may consider, and it's more likely that we would consider the ineligibility of an individual permanently than we would necessarily a firm. And the reason is firms change their personnel, they change their hierarchy, they change their ownership, they can bring structures in, compliance programs. So it's more unlikely that that would ever apply to a firm.
Thank you very much, David. So, Jeff, I've got a wonderful question for you from one of our active participants. Can an EA exclude an entity on its own blacklist from evaluation? Jeff, over to you.
Yeah, the very simple answer to that is no. But if it depends on the reason that they were blacklisted as well. So it's certainly an argument you could put to ADB to consider, but we would not recognize an EA's blacklist automatically. If the reasons for that were contractual non-performance and they were in the immediate past, it doesn't then become a sanctions question. It then becomes a qualification question. So we wouldn't look at it from the perspective of sanctions and recognition of a borrower or an EA sanctions list automatically, but we would look at it from the perspective of, is this bidder qualified to perform the contract? So if, for example, you had a bidder that had just defaulted on a contract and you had followed all of the contractual remedies and shown fault, you have terminated for cause, you have been challenged at arbitration or not, or in the courts or not, and successfully had the termination upheld, it's something we would certainly look upon sympathetically. But I couldn't say automatically, yes, we would recognize an EA sanctions list. But if it was for reasons of contractual non-performance, it's something we would certainly look at from the perspective of qualifications rather than anti-corruption.
Thank you very much. Thanks,
the
Jeff.
other one, the question just before that, and I'll read it. What if there were two bidders participating in a bid, and while verifying their bid securities, it is found that one bidder's bid security had been issued by a bank at the request of another? And I would say, certainly, that should be referred straight to my colleagues, David and Lisa and John, as a potential breach of ADB's anti-corruption policy, and would look prima facie to be evidence of collusion.
Yes.
That you have one bidder providing a bid security through a bank to one of its competitors.
Yes, again, I agree with Jeff, prima facie case, that would be very unusual. It would be a red flag that there is either one, a conflict of interest, or two, there is a collusive practice that two bidders are getting together to try and change how the decision of an award is going to one or the other particular firm. So yes, it would need to be reported. And then it would be assessed by OAI as part of its investigation.
Thank you very much. We have another question sorry, if a contractor after awarding the contract goes into sanctions, what is the case? So what happens is ADB typically, if an entity is debarred or temporarily suspended after the contract is awarded, the contract ADB normally allows for the contract to continue. However, if there is a modification, extension, or variation of the contract in relation to that debarred or suspended contractor, then the Office of Anti-Corruption and Integrity needs to be consulted, and we will advise and approve. The main reason being is to ensure that no variation, extension, or modification is used to circumvent the debarment or suspension. David, another question, a question for you, please. I appreciate that some people may have come in a little bit late, so when they were joining us this morning. What are the criteria for sanctioning a company? Would you mind summarising those again quickly, please?
Yeah, and again, I'm assuming when you talk about the criteria, it's in relation to the integrity violations, because we conduct an investigation, and our investigations are purely into the integrity violations for third-party bidders. And so we have to demonstrate as part of our investigation, and by the way, our investigations are to the civil code, which are on a more probable than not basis. It's not criminal. We don't have to prove beyond all reasonable doubt. And so we look at, let's say, elements: fraud, corruption, collusion, coercive practices, conflict of interest between bidders, and or conflict between members of the EA and the bidders, for example. Abuse, and I use the most frequent one, which is theft of assets on a project. An obstructive practice, which is particular to our investigation. If a firm fails to provide information, destroys evidence as part of the investigative process, we would have the right to charge them with an obstructive practice. Retaliation, we have several cases that we've investigated where firms have retaliated against individuals or other firms for submitting their details as part of an integrity violation to the EAs or to OAI. And then there is what we've predominantly been talking about today, a sanctions violation, where a firm or an individual is, well, so for this particular case, a firm is already debarred and they submit bids either in their names, their subsidiary's name, or even a new name to circumvent the debarment process. So we have sanctions violation. And then the last broad violation that we can have is the failure to adhere to the highest ethical standards. So that's the criteria that we will review, and we have to obtain evidence to put our case forward that an integrity violation has been conducted.
Great, thank you, David. We've got more questions still coming in. Will the entity be excluded from ADB debarred list automatically after the debarment period is over? No, it is not automatic reinstatement. The individual or entity needs to apply for reinstatement. We have had some questions during the chat previously on some of the processes. We may ask for an independent evaluation, for example, monitorship or the like. David can give more flesh on that, but just to reiterate, it is not automatic. So unless reinstatement is applied for, then they will stay as a debarred entity. David, would you like to add more?
Yeah, so we issue notices of what we call sanctions notices. We issue those to the entities that have been debarred, and we will send those both by email and by courier. So when the entity receives these, they know that the specific conditions that they need to abide by, and they know that they have a minimum period of debarment. And in the minimum period of debarment, as Lisa has quite rightly mentioned, the firm or the individual needs to apply for reinstatement. If it doesn't apply, it remains debarred and the date just goes to no date because we don't know when they're actually going to submit an application, but they can submit an application any time after the minimum period. And even if they submitted an application, but they were not reinstated, we may either extend the debarment period for a particular period of time, or it may be again extended until such time they can meet the conditions of the debarment. So they have to be reinstated and there has to be an action by ADB to reinstate.
Thank you very much. We've got a very good question, and it may be, unfortunately, the last that we can fit in today, but it is a very good question to end with. It is, if one of the firms under a consortium of consulting firms applying for a project finds that one of the firms is blacklisted or has a conflict of interest, then either the whole consortium will be to get disqualified, or is it only the firm that will, with the issue, that will be eliminated from the consortium and the rest will be evaluated?
Jeff should answer this.
Yeah,
first.
sure. I'll start. As a generality, the whole consortium will be disqualified. As a generality, because the entity making that proposal was joint and several, but also singular. So you've no longer got a binding proposal to consider. It's a lot more clear cut when we're looking at construction or supply contracts, but the same logic extends over to consulting. It could be mitigated somewhat if it was an individual, but one of the things we want to look at in such a case, certainly in the case of ADB Sanction, what was the role in the lead firm? Was it diligent and so forth in ensuring that it was proposing an eligible firm? Did it ask the questions that Ralph asked earlier in this conversation? But as a generality, yes, they would be out. David?
I'm educated, Jeff. Thank you for that response. And again, you know, if it was found that the consortium had a blacklisted entity, of course, we would then need to investigate how that consortium was construed, what representations were made in relation to, one, the particular entity itself, but also the role of the other firms in the consortium. A bit like what we were talking about earlier about getting the certification from the partners. If there is a positive certification from that party that it was not blacklisted, then we have very little to investigate with the other consortium members because they did adequate and proportionate checking, due diligence. Now, the conflict of interest is a little bit more interesting because, again, where is the conflict of interest? Is it a direct conflict of interest with the EA, or is it a direct conflict of interest with another bidder? And that would also fall under our procurement guidelines as to what is permissible of the consortium. Suppliers, I believe, Jeff, you can have multiple agreements and be in the supply, but if you're a consortium member and then have any other involvement in another bid, that is a conflict of interest under our procurement rules.
Yeah, and the interesting and the challenging thing about a contract conflict of interest, it doesn't have to be proved, it has to be perceived. So if the perception is there is a conflict for the purposes of the regulation. But the perception is on the part of the EA. I have seen EAs argue that a certain relationship is not a conflict and accepted that argument. I have seen EAs argue that a certain relationship is a conflict and accepted that argument. So it is very much based around the perception of the evaluator or the purchasing entity. I mean, there are the cases where it's very clear there is a conflict, where you have the same subcontractor performing 80% of the works in 5 bids. Yes, because they are going to control the outcome of the bidding process. Whereas you may have the same supplier with a critical element or tap changes on a transformer, for example, offering across every single bid, and there'll be no conflict. So it will depend on the circumstance, and conflicts of interest are fascinating, but it depends on the perception of that conflict as well as there being the potential. It's not actual, it's more perception and potential than actual.
Thank you, Jeff and David. So on that note, I would like to take the opportunity to firstly thank the speakers during this session, being Jeff, Rustam, David, and John Fort, the head of the Office of Anti-Corruption and Integrity. Most importantly, I would like to thank all of our participants today. You have made it a wonderful session with your very lively debate. It is a shame we can't do it in person, but we have been very fortunate to hold this session and do such great outreach and engage as we have. On behalf of ADB, I thank you all for your ongoing partnership, for being integrity champions, and in some instances, we've also said that you could reach out to your respective POs for additional questions. So if everybody would like to please undertake this survey, the answers are kept confidential and we assess them in the aggregate. They really do help ADB shape our ongoing outreach. This QR code shown on the screen is in English. In the chat is the links to the QR codes in our other languages provided today, and your feedback is really helpful to ADB. So on behalf of ADB, the speakers, the organisers, we thank you very much. Please stay safe and we hope to see you in person soon. Thank you.
Thank you, everybody.
Thank you, Lisa. Thank you, Jeff.
Thanks. Bye-bye.
Take care.
So this is it. Thank you very much. Maraming salamat po. Siasiani, Dan Vayavad, Saumarkun, Bayarsa, Spasiba, Shukriya, Kamen. Thank you very much and goodbye.